الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا وحبيبنا محمد حبيب رب العالمين وعلى آله وأصحابه وأتباعه إلى يوم الدين. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا بفيض فضلك رشدنا يا رب العالمين. Alhamdulillah, in our lessons on Multaqa al-Abhur of Imam Ibrahim al-Halabi, rahimahullah ta'ala, we have, by the grace of Allah, mighty and majestic, reached al-istisna. And we're moving from the core sections related to buyu', and then soon we'll be moving into things that support sales contracts. Now, last lesson, we looked at salam, correct? And what makes salam unique as opposed to other contracts? Like, what makes salam unique vis-a-vis just a regular sales contract?
The item of sale isn't present.
Yeah, so what's the problem with that? It's present, it's absent, maybe it's like a bad student. What's significant about that?
You can't sell anything you don't possess.
Yeah, so the basis is that in general, the rule is that you cannot sell something that you don't possess, and you can't sell something that doesn't exist. Right? So there's two governing concerns, correct? You cannot sell that which you don't possess, and number two, you can't sell that which does not exist. Right? So there's two big problems with the salam contract. But why was the exception made with the salam contract, Saadati? Why was an exception made in the salam contract?
The salam contract is binas.
Yeah, bin nas. Good. Textually, it is established that the salam contract is a permissible contract. Right? So it's established for us textually by text of the Quran and by relating, supporting hadiths. So this is a type of istihsan, right? Legal preference by the nas, right? So we leave the general principle. Of course, the general principle, where is that established from? By the nas as well, right? It's not just the Hanafi sat down and decided to put together some cool principles to make law make sense, right? And this scares the other madhahib, especially some more than others, but that's the underlying basis. Okay, tawakkalna ala Allah. Now, in the same light, we have the istisna. The istisna contract is also an exceptional contract, but there isn't an explicit textual basis for it. And we'll see why. So today we're going to see, bi'idhnillahi ta'ala, regarding the istisna contract, that unlike the salam, right? The salam has explicit textual basis from what? From the Quran, from the hadith explicitly. The istisna contract is established primarily by the existing urf at the time of the beloved Messenger sallallahu alaihi wasallam. Right? As the author of the Ikhtiyar says, that the Prophet sallallahu alaihi wasallam was sent and people dealt with istisna contracts. Right? Manufacturing contracts. The Prophet sallallahu alaihi wasallam gave something to be made as a contract. And so we see that in that practice of the Prophet ﷺ, but the practice itself is an individual incident. Can an individual incident condition a general text in the Hanafi school? No, right? Because an individual text, what is its dilala? What is its indication? Is it qat'i or dhanni?
Dhanni.
Dhanni, right? So the Hanafis would incline to interpret that in line with the explicit, general principles, right? Because there's a coherence to the law. But there's also a general practice. There's a urf amali at the time of the Prophet ﷺ that the Sharia concurred with. Right? So we will see, right, that the manufacturing contract and also today some of the other masail, what's called masail shatta, as well. So this idea of the manufacturing contract is that the salam is a very structured contract. It has very key, critical conditions. What's one of the most difficult conditions to fulfill in the salam contract? With respect to payment. In the salam contract, what's the challenging aspect with respect to payment, for example?
Color rust on man.
Yeah. The payment has to be made when?
Upfront.
Yeah, upfront, right? In the majlis, before they part. So that may be difficult to someone. You want something made, but you can't pay for it upfront because you may not trust the person. So that's why the manufacturing contract is like a simplified salam contract. Okay, it's a simplified salam contract. So we're going to see the related governing principles to that. And there's a number of other issues that come up in Masail Shatta that, we will see. So let's look at this Aqd al-Istisna as the first thing, the manufacturing contract. So the basis of the manufacturing contract is that there's an ongoing practical urf, right? That people were engaged in manufacturing contracts at the time of the Prophet ﷺ, and the Prophet ﷺ approved of it. And despite the general principles that relate to not selling that which is not known, the Sahaba and the Tabi'een who understood prophetic teachings continued to see that as an exception. So we understand that this is an exception from the general principle of the impermissibility of selling something that does not exist. But then it's a weak contract, right? Because the item of sale, does it exist? Right?
No.
It doesn't. Has the payment been made? No, not necessarily. It could be not. So the early Muslims had some differences that, firstly, is it a wa'ad or is it a aqd? Right? Is it a promise or is it a contract? And it is a contract. That's number one. Right? It is a contract. It is not merely a promise. That's the first thing. The second thing, is it binding? Is a manufacturing contract binding? So the transmitted position in the Hanafi school is that given the weakness of this contract, right, vis-a-vis the general principle, because you haven't seen what you're buying. right? There's too many intangibles with that. So the transmitted position in the Hanafi school is that there are conditions for the manufacturing contract. However, the manufacturing contract has to be, though a contract, it's not binding, such that even if the person delivers what you asked for, you're not bound by it. So let's try to understand. For example, I have a friend who has a leather bag company. It's called Summit Bags. Even if a bag was described to me fully, right? That, okay, I want the bag this way, this way, this way, this sizes, etc., etc. The person made the bag. Is it necessarily what I wanted? No, right? No. Right? That key element of taradi, it may be missing, right? So to guard from that, it's not a binding contract. Even if it's, okay, it's dark brown, it's this way, everything, but in any item of sale, there are intangibles that are hard to define. So the basis in the Hanafi school, the transmitted position is that to preserve this wasf of taradi, because whose taradi is most important? The buyer or the seller? Who's rida? The buyer, right? Because what does the seller get? The seller gets the payment, right? The seller gets the payment, so it's not much of a problem. But the buyer, the mushtari, they're getting the item of sale, which is the subject of the transaction. So that's why it's the transmitted position is that it's not a binding contract. But we see also that there is an intangible element in a sale, in a transaction. So it's like it's an element of trust involved. Now, the Muslim, if they make a promise, are you legally bound to keep the promise? In general, if I said, say, Abdul Latif, I'll help you move tomorrow. Can you take me to court for not helping you tomorrow?
No.
If something came up, I had to take someone in my family to the hospital, whatever, am I necessarily sinful for that? No, right? Because fulfilling a promise, what is its ruling? Right? Oh, sorry. The fulfilling a promise is a sunnah, right? But it returns back to the underlying aspect of trust. La imana liman la amanata lah. Right? So trust and being trustworthy is a central value of our deen, and trusts relate to the obligatory, but also to what you have been trusted in, even when it's not binding. I gave you my word, I'll be there tomorrow. So later ulama, like this is post Ibn Abdin, time of the Majalla, they were dealing with two very sensitive things. The first is the reality of the weakening of people's trust. People not fulfilling their word. And this is a central virtue of Islam that other civilizations noticed, that Muslims took their words very seriously. And it relates to the honor of a Muslim, right? The karama of a Muslim, and their kalima, and their word, and this having honor and trust are two of the core values of the deen. So given that weakening on the one side, but also hitting the industrial age where things could be made in bulk and at a large scale. Auntie Huda asked for 75 fuchsia colored plastic chairs for her backyard. and they're made exactly to specifications, said, nah, I don't want it. But then it's a harm for the seller. Right? So they took a different tack, and we'll look at that in a moment, which is that the position taken by the Majalla, right, with due consultation of the Majalla's committee, which constitute some very great scholar, Ahmed Jawdat Basha and Amin al-Jundi and Ala ad-Din Abidin, Ibn Abdin's son. They took a narration in the madhab from Abu Yusuf that if the contract is exactly, if the item was delivered as specified, it is a binding transaction. It is a binding transaction. So that's the fatwa position, that the manufacturing contract is binding. Okay. So what are the conditions for the validity of Aqd al-Istisna? There's a good summary in Mufti Abu Lubaba's summary notes in the Ikhtiyar. Right? So there's an edition of the Ikhtiyar with Mufti Abu Lubaba's critical edition and notes, and he summarizes these points. Right? And you can take them from the slide, right? That for the istisna to be valid, it has to be something that requires manufacture. It has to be made. So you can't just give it for example, delivering of produce, for example. Because do you manufacture produce? Produce being like, crops, for example. No. Because that would fall under bay'ul ma'doom. This is something that is made. This is made. So you cannot do that for, the future delivery of things that are not manufactured, but they grow, like the offspring of animals or produce, etc. That's number one. So it has to be for something that is manufactured. Number two, it requires precise definition, as we will see from the text itself. Thirdly, we cannot specify the time period for the istisna. Contractually, we can agree on it on the side that, okay, deliverable on such and such date. Why? Because once you define the ajal, what does it resemble then?
Salam.
It becomes salam, as the author tells us, right? Because that is the strong contract. The strong way of doing this is salam. And that's the strong exception. This is the weak exception. And the general thing is that the Sharia does not like speculation. Right? The salam has to be something generally that is present in the marketplace, right? Etc. And we looked at the conditions for that. So these are from the fourth condition for validity is that it's something that is customarily dealt with for the purpose of manufacture. Right? It's customarily done for manufacture. Right? That you can't, if someone says, okay, so something that people don't customarily do manufacturing contracts for, it would not be a valid manufacturing transaction because it's thabit bil urf, so it remains limited to that. Okay, so let's go to the text. He tells us والاستثناء بأجل سلم فيصح فيما أمكن ضبط صفته وقدره تعورف أو لا. Right? right? So istisna is, he doesn't give us a definition, right? Istisna, and you can, istisna is defined as طلب عمل الصنعة والعين. It is to request the work and the resultant product, right? So it has two aspects, right? It is طلب عمل الصنعة. It is to request the making the thing and its output. So if someone makes, they for example, let's say you make a manufacturing contract for particular type of tables. They did the work, but then they weren't able to deliver the table to you. It's not just over the work. It's to make the item and give you that item itself, because ultimately the subject is the resultant item. Okay. If you define an ajal for it, it is salam. So it's valid in the things that are properly defined. In that whose sifa, its characteristics, and its qadr, its extent, are definable. Right? Are definable. Right? So this fa, what does it relate to? فيصح فيما أمكن ضبط صفته وقدره تعورف أو لا. This fa relates to which? That the istisna with ajal is salam, even if you called it a manufacturing contract. So if you say that manufacture this table for me, deliverable in 30 days. The person says, I agree. And it was fully defined. Like you gave the whole description, etc., etc. The person agreed. Even if you called it manufacturing contract, that would be, what would it be? It would be salam. Right? So this fa here, said that the fa here, فَيَصِحْ, this would be, if it is salam. The salam is not conditional to something that is muta'araf, right? That is customarily made. Right? So with duration, it's salam. It's a forward sale. And in that case, it doesn't have to be something that is customarily done. وَبِلَا أَجَلْ يَصِحْ فِيمَا تُعُورِفَ فِيهِ. And without specifying a time period, it is valid, i.e. as a manufacturing contract, in the things that are customarily done as manufacturing contracts, كخف وطست وقمقمة. Right? كخف, right? And الطست is الطست and القمقمة are types of containers. The qiyas is it's not valid, but the ta'amul was that there are things that people customarily made. And generally there were small things that people had need for, but you didn't need to make an ajal. They're based on trust. They're based on trust. You give it to someone you trust, so you trust that they'll deliver it for you. They trust that you will pay them. You didn't have to set a due date because of this trust. Now you can have a separate promise of when they'll deliver it, and that would count as a promise. What are promises based on? They're also based on trust. Now it's sad, but it's a reality. So that trust has diminished. And we've taken the other one, which is why this was considered binding post Majalla. So, right, this is why even the example, these are small things like a khuf or containers, right? Right? And then he tells us, rahimahullah, that وهو بيع لا عدة. Right? And it is a sale. A sale meaning it is a contract, not merely a promise. And that is the relied upon position in the madhab. So it's a contract, not merely a promise. Because a promise is not binding on either side. You say, would you manufacture this? Would you make me a sibha? I say, sure, inshallah, I'll do my best. I'll try. Is that an acceptance?
No.
No, right? That is simply a promise. Right? I'll try, I'll do my best. This is why in transactions, very important to be specific. I was just over the weekend working with 3 professionals who had a multi-million-dollar partnership, but it was all, we're friends, we're buddies, etc. It was not clear what was contractually agreed upon and what were promises or just general commitments, not even promissory. Right? And when you differ, each party has a different understanding of things. So it becomes very messy. So it is a bay', meaning it is a contract. Right? It is a contract, not merely a promise. Right? فَيُجْبَرُ الصَّانِعَ عَلَى عَمَلِهِ. So the manufacturer, i.e. the seller, is forced to deliver. Right? And there are some positions to the contrary. Right? وَلَا يَرْجِعْ المستصنع عنه. Right? Right? And the one who requested the manufacturing does not go back on it. Right? It's it is, you can't, once the manufacturing contract begins, you can't just retract the contract unilaterally. Right? Because the person is manufacturing it. Right? وَالْمَبِيعُ. Right? So it's binding initially. وَالْمَبِيعُ هُوَ الْعَيْنِ لَا عَمَلُهُ. Right? And the item of sale is the item manufactured, not just the work. Right? So initially, the contract, it's a contract, right? It's binding on both parties. Insofar as the seller has to manufacture the item, and the one who requested the item, called the mustasni', the one who sought the manufacture, the buyer, cannot go back on it. It's binding. Because you enter into it, the person bought the things, etc. But this is the nuance, right? He says, فَلَوْ أَتَى بِمَا صَنَعَهُ غَيْرُهُ أو بِمَا صَنَعَهُ هو قبل العقد فأخذه صح. Right? So if the manufacturer, the seller, delivers something made by someone else, or that they themselves had made before, right? I.e. before the contract, and the person takes it, it is valid. Right? Because what you sought, what the buyer sought was there. Okay. And then he says, وَلَا يَتَعَيَّنْ لِلْمُسْتَصْنِعِ بِلَا اخْتِيَارِهِ. The item does not become specified for the buyer, the mustasni', without their choice. Right? Because you asked for this item to be manufactured. The leather bag maker made a leather bag as you requested. Someone liked it. He could give that bag to him and make you another bag. Right? So So that's straightforward, right? And then he says, فَيَصِحُّ بَيْعُ الصَّانِعِ لَهُ قَبْلَ رُؤْيَتِهِ. So the manufacturer can sell it, i.e. to a third party, before the mustasni', the one who asked for it to be made, sees it. وَلَهُ أَخْذُهُ وَتَرْكُهُ. Now this is the challenging part, right? And the buyer has a choice when it's delivered whether to take it or not to take it. وَلَهُ أَخْذُهُ وَتَرْكُهُ. Right? So it is a contract that is at the end, when the item is made, not binding. Why? Because there's a principle that this falls under. If you buy something you haven't seen, what do you have the right to? من اشترى ما لم يره
رقية.
فله الخيار إذا رآه. If you buy something you haven't seen, you have the option of accepting it or not. Why? One, because that's a general principle understood from the Sunnah, and this manufacturing contract falls into it, and because in items of purchase there are those intangibles. Okay, this is even if it is as described. Now, for Islamic law in general, we have to appreciate this aspect of their underlying values that make it almost inconceivable for certain things to happen. Right? Because law, right? For example, in a traditional society, would it be conceivable that an adult son pay rent to his father for continuing to live with his parents during university? In most traditional societies. No, it would be like, if family knew, the neighbors knew, the friends knew, it'd be like death, right? That your son is living with you and you're charging them rent? People, now can one adult charge another rent to live in their house? Yes, right? But we have to understand particularly these notions of honor, particularly two of the many values, honor and trust. Right? Honor, the karama of the mu'min. لَقَدْ كَرَّمْنَا بَنِي آدَمَ. It's not just al-mu'min, bani Adam, right? The sense of honor that the human being has. And number two is trust. However, if you look here, right, وَلَهُ أَخْذُهُ وَتَرْكُهُ, right? And this is on the basis of خيار الرؤية. On the basis of خيار الرؤية. Right? Which is established for them and for others. Okay. But then the narration of Abu Yusuf is mentioned here, incidentally, in Majma' al-Anhur, right below. It says, وَعَنْ أَبِي يُوسُف أَنَّهُ لَا خِيَارَ لَوْ لا خيار لواحد منهما. Right? That there's a narration from Abu Yusuf that if delivered as specified, neither party, neither the seller, the sani', nor the buyer, the mustasni', has the option of cancellation, if as described. And that's what the Majalla took in the related items, and we'll give those items, right? ولا يصح فيما لم يتعارف كالثوب. And it's not valid, i.e. istisna is not valid in the things that are not customarily commissioned for manufacture. Right? He says كالثوب, such as garments. Unless made as a salam. Right? Unless made as a salam. Okay, so that's the manufacturing contract. And for that, inshallah, we will share, Sidi Abdul Latif, remind me that we'll share two discussions. One is the associated items from the Majalla, and number two, the associated section from the abridgment of fiqh al-Buyu', the Mashru' al-Qanun, right? You can nudge Sidi Umar to share those, right? So now practically, the manufacturing contract gives us many opportunities, right? That if in things that are customarily made, right, that you can make it into a binding contract. So let's say, you want to make custom sibhas, but you want to make it binding. You want to make it binding. So you give descriptions, you give, but the onus would be in a manufacturing contract to define things fully. One of the things is to give very clear, detailed descriptions. Right? And that's something that a lot of online sellers don't give enough information Islamically, right? A lot of Muslim booksellers, like I regularly make istighfar when I'm buying books online. Because the booksellers, and that's not related to manufacture, the books already exist, but they're insufficiently described. So as a buyer, I have no way of knowing you're shipping me these books, but I can't tell if it's a good print, a bad print, any information about it. So that's, in general, that's poor sales practice. But when it comes to manufacturing contracts, someone wants to start a business, they want to manufacture things. Right? And in our times, you could do it even for tailoring, but you can make it binding. Right? I'll make something to you as described. You give a sample, you give, visuals. Now it's very easy to take images, etc., of the texture, etc., and you make a sale. Now it would be from virtue to have a refund policy for it. But could you make a manufacturing contract out of selling oud, for example, that you sell expensive oud and say it's a manufacturing contract? I will make some oud for you. Can you use that? No, but why? What's the condition? Because why, Sidi Abdul Latif? So you want to?
Oud would be.
Go ahead.
Oud would it be difficult to do the manufacturing contract because it's customary not done?
Okay, but also, are you manufacturing something?
No, it's not something that was normal.
Right. So those are things that one thinks through. That okay, is this something that? But for example, for tailoring, right? Tailoring, you could define it as a salam, and that's much simpler, right? Or you could define it as a manufacturing contract. And then many issues come up. Do go through the section in the abridgment of fiqh al-Buyu'. They give many useful examples. And people should know these well because, as we said, it's important for Muslims to start business initiatives, right? But to do them properly. Okay. Now the next section is assorted issues at the end of sales called Masail Shatta. And these are, we'll go through these reasonably fast. يصح بيع الكلب والفهد وسائر السباع. It is valid to sell dogs, right? And fahad. What's a fahad, folks? and all wild animals, right? A fahad can refer to a cheetah or
lynx.
Yeah, or lynx, right? Because they have some usage, right? That, okay, you can't keep a dog as a pet, but you could, what else can you do with the dog?
Hunting dog.
Yeah, you can use them for hunting. You can use them as a guard dog. You could take the dog and use its skin, right? So anything that has some permissible use is permissible to sell. So all wild animals can be bought and sold in of itself. And that includes cats and birds. Keeping pets, of wild animals is a separate matter. And it revolves around, number one, that you will take care of it. And number two, that you are able to give it its rights. Right? So you keep like for example, if someone wants to keep a caged bird, for example, they keep it in a cage that's large enough for it to fly in. Right? If you keep, you keep the kind of animal that lends itself to be a pet. Some of the Salaf did not like the keeping of those, but there are many of the Salaf that did keep different types of pets. Of course, the most famous is cats, because that's textually established. But certainly keeping large animals in small spaces is against Islamic teaching. So anyway, that comes up in the ahkam of halal and haram. But these are valid to sell because anything that has a permissible usage is permitted. Okay. علمت أو لا, whether it has been trained or not. And whether the dog, etc., have been trained or not. That's one principle. Another principle is that وَالذِّمِّيُّ فِي الْبَيْعِ كَالْمُسْلِمِ, that when it comes to sales, the non-Muslim in a Muslim land is like a Muslim, right? That what's valid for a Muslim to engage in is valid for a non-Muslim to engage in. We can buy and sell with them, etc., in all matters except for the fact that إِلَّا فِي الْخَمْرِ, except for alcohol. فإنها في حقه كالخل, because non-Muslims are allowed to transact in anything that is mal. A Muslim can transact in anything that is mal, but there's another criteria which is متقوم. ما أبيح الانتفاع منه شرعا. But they're not bound in worldly terms by that. So this is from the broadness of the Sharia, right? That in Muslim lands, we let non-Muslims be between themselves. They can engage in invalid transactions that they recognize. They can engage in invalid types of marriages if they deem them to be correct. And the governing principle is أُمِرْنَا نَتْرُكَهُمْ وَمَا يَدِينُونَ. We've been commanded to let them be and that which they deem to be correct. But they're not allowed to spread those things amongst the Muslims. Right? So if they opened a liquor store, it would have to be in a non-Muslim area, and there'd have to be guidelines that they will not sell. They make a commitment not to sell to Muslims, even if a Muslim comes to them. Right? That's why some Muslim travelers, and not all travelers who are Muslim or pious, would say that if, وَالْعِيَاذُ بِاللَّهِ, that if you're looking for alcohol, look for where the churches are. That would be the non-Muslim area. Nasallallahu al-lutf wal-afiyah. Okay. And he says, وَالْخِنْزِيرِ فِي حَقِّهِ كَالشَّاةِ, and pigs with respect to non-Muslims are like cattle. Okay? So this is between them. And the governing principle, أُمِرْنَا نَتْرُكَهُمْ وَمَا يَدِينُونَ. Right? So if they differ regarding these things, we say resolve them in your own courts, right? And okay. And then he says, وَمَنْ زَوَّجَ مَشْرِيَّتَهُ قَبْلَ قَبْضِهَا جَازٍ. Right? That whoever marries off the emma that they purchased before taking possession, this is valid. Because once acquired, it is milk even if you haven't taken possession of it. فَإِنْ وَطِئَهَا كَانَ قَابِضًا وَإِلَّا فَلَا. Right? فَإِنْ وَطِئَهَا فَإِنْ وُطِئَتْ, if intercourse takes place, i.e. from part of the husband, not the purchaser, that would be like the one who purchased them taking possession of it, otherwise not. So this is a random issue that doesn't have a lot of application. Now, sometimes a problem can happen that the buyer disappears. Someone purchased something, they haven't paid for it, but they disappear. Now, what do you do? And so this has been dealt with, alhamdulillah, as follows. وَمَنْ اشْتَرَى شَيْئًا فَغَابَ غَيْبَةً مَعْرُوفَةً لَا يُبَاعُ في دين بائعه. Right? 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 If someone buys something, yeah, that's a transferable item, and they disappear in a known, and for known disappear. They've gone for vacations for a reasonable amount of time, right? لا يباع, that item cannot be sold, right? To clear the amount owed, right? So the person's in hospital, for example, right? To be fair. So a sale took place, but the person hasn't come to pay for it yet because they're in hospital. Once a sale takes place and they're known where they are, it's known where they are, so you give a reasonable opportunity for, okay, can you either just go and get them to pay? Because once the sale takes place, who does the item of sale belong to? To the buyer. Right? And you agreed to sell it to him, and you agreed not to take the payment up front. So there's rights and responsibilities in the sale. Right? So it's not immediately sold off, because the person may have a reasonable excuse. Right? So the item is not immediately sold. وَإِن لَمْ يَكُنْ مَعْرُوفَةً, but if they disappeared and it's not known where they are, and the disappearance is not known, like where are they, how long are they away from, etc., beyond that which is customarily accepted, يُبَاعُ فِيهِ إِذَا بَرْهَنَ أَنَّهُ بَاعَهُ مِنْهُ إِذَا لَمْ يَكُنْ قَبَضَهُ. Right? The item would be sold to clear the amount owed to the seller if he can prove that he sold it to that person and that the person had not taken possession of it. Right? Two, here the person disappeared. He said, okay, I'll pay you within 3 days, right? Because there was a ta'jeel. The person disappeared. Of course, in court, the person would have to be asked that, have you given them enough time, etc. And diyanatan would be, okay, what is a reasonable delay? What is a reasonable delay in payment? It would depend on the size of the item, etc. Some said, for example, a month for regular items, right? But it's a custom item, etc. But also all reasonable attempts have to be made to contact the person. وإن غاب أحد المشتريين فللحاضر دفع كل الثمن وقبض المبيع وحبسه إذا حضر الغائب حتى ينقض حصته. So here the situation is, if two people purchase an item together, so there's a fine piece of calligraphy. See, Abdul Latif and I both liked it, but it was very expensive. It's $1,000. Neither of us could afford it on our own. Said, okay, let's buy it 50-50. Okay. So what happens? I forgot about it. I traveled. That's the surah al-masala, right? وَإِنْ غَابَ أَحَدُ الْمُشْتَرِيَيْنِ. So one of us disappeared, me. So the one present, Sidi Abdul Latif, he can't just say, okay, I'm going to pay my part and take the piece of calligraphy. No. You have to pay the full price, and then you can hold on to it and not let me share it until I've paid my part of the price. It could be one item, or there's other in other scenarios here. وإن اشترى بألف مثقال ذهب وفضة فهما نصفان. So if one purchased 1,000 mithqal in gold and silver, it would be 500 in each of each. And this goes back to usage. Okay? This goes back to usage and context. It's hard to, the better thing to do would be to clarify beforehand. Someone says, okay, that'll be $1,000 American and Canadian. Right? What does that mean? We go back to linguistic usage. But the moral duty on both parts, because in transactions, the idea of taradi, that which affects taradi, should be dealt with proactively. Right? وإن قال بألف من الذهب والفضة فمن الذهب 500 مثقال ومن الفضة 500 درهم وزن 7. Right? So if one says it in this different way, it would be according to what is customarily the measure of gold and the measure of silver. Okay. ومن قبض زيفا بدل جيد غير عالم فأنفقه أو هلك فهو قضاء. Right? So now there are different terms for types of currency. So the zayf, right? The zayf is that which, right? The zayf is that which is not pure, but in the marketplace people trade in it. So you have the jayyid, the treasury would accept it, and it's accepted in the marketplace, right? It does not have ghish. But the zayf has ghish, has cheating in it. There's a mixture, but in the marketplace, people accept it. Now, that doesn't apply with paper currency, right? Because it's either currency or it's not. Right? But to understand the principle, right? So this is what the zayf is, lower quality coins, but these are accepted to trade on, right? Someone takes possession of some of these and not knowing that it's the lower quality coin, he spent it or is destroyed, nothing is due on them. Okay. وقال أبو يوسف يرد مثل الزيف ويقضي الجيد. Right? And Abu Yusuf said, one returns the like of the zayf and you pay with the jayyid, with proper quality coins. Right? And many of the later scholars gave fatwa on it, on this position, right? That no, the zayf cannot be traded in. But this goes back to what is accepted in the marketplace and what the authorities allow to be traded in. Because if the zayf is not accepted in the marketplace, or the authorities do not allow it to be traded, then transactions on the basis of that would not be allowed. Right? So that's where the position of Abu Yusuf is mentioned. Okay. وَإِنْ فَرَخَ طَيْرٌ أَوْ بَاضَ فِي أَرْضٍ أَوْ تَكَنَّسَ ظَبْيٌ فَهُوَ لِمَنْ أَخَذَهُ. Okay. So, if a chick hatched or gave an egg in a land, or a gazelle started dwelling in a land, so it belongs to the one who takes it, right? Right? Because the basis of these animals is that they are mubah, correct? It's a free animal. So someone captures it, it's theirs. Unless the person whose land it is has either enclosed their land or set up enclosures for gathering the animals, right? Because you can't enter somebody else's land and take an animal, right, that they have made theirs. But the basis is that free animals are free. You could hunt them and you could, you could take them. But you can't take somebody else's animal or that which they have prepared the capture of. So these are random assorted issues. وكذا صيد تعلق بشبكة منصوبة للجفاف أو دخل دارا, right? And likewise, some hunting animal that got attached to a net that was hanging to dry things. So there's a net that's hanging meat to dry. So a hunting animal gets stuck in this net that was not for hunting. It was for drying meat, for example. It was a fisherman's net. Right? So Uncle Masir decided to go hunting for gazelles. There's a fisherman who'd put up a net by their boat to dry. Because, they're hunting with nets. Uncle Masir's attempt to catch the gazelle wasn't successful, but it got stuck in the fisherman's net. Is that net for hunting? No. So Uncle Masir could take that shabaka, that net, that's hanging for drying, for example, or if it enters someone's dar. So you're in someone's house or someone's backyard, for example, and a wild deer jumps into the backyard. Can you take that deer and say, okay, that's my dinner? So you say, that's my dinner, my dear, and you and your wife take the deer home? Yes. Right? So that's the example. So permissible animals are permitted to capture. وَدِرْهَمْ أَوْ سُكَّرْ نُثِرَ فَوَقَعَ عَلَى ثَوْبٍ. And likewise, you can take a coin or sweets that were thrown and that fell on a piece of cloth. Right? So someone put their shawl down to make wudu, and someone, they would often, in celebrations, whatever, they throw coins or throw sweets, throw like candy for people to pick up, etc. It's fine. It's not the best thing to do. It's better to put it on a tray and for people to pick it up. But people would do this. If they did, if some sweets fall on someone's bag, for example, that's on the ground, does that become that person's? No. Because taking ownership they have not taken possession of that item, right? Just the fact that it's on their item, so you could take it. Okay, so these are assorted issues. فإن أعده صاحبه لذلك أو كفه بعد السقوط أو أغلق باب الدار بعد الدخول ملكه وليس للغير أخذه. But if the person who had the trap, right, had prepared the trap for this, or they'd gathered the animal after it landed on their property, for example, or they closed the door of their house, right? Or they took the sweets that were thrown, for example. In these cases, because they took possession of it, then it's theirs, and then it's no longer mubah, and it cannot be taken by another. كما لو غسل النحلة عفوا كما لو عسل النحلة في أرضه, right? أو نبت فيها شجر. Or if someone prepared, took care of honeycombs on their land, then the honey from those honeycombs is exclusively theirs. Someone else cannot take it. Or, trees or plants grow on their property, it's your property. أو اجتمع تراب بجريان الماء. Or if soil gathers on your property by the flowing of water, in all of these cases, it's considered to be gathered, so it's the owner's and someone else cannot take it. So these are the issues that we wanted to take today. There's just one minor thing that remains, which is what is invalidated and not invalidated by conditions. So we look at this. We won't expand it extensively, right? Right? So he says it's a section, right? That وما لا يصح تعليقه بالشرط ويبطله الشرط الفاسد البيع والإجارة والقسمة والرجعة والصلح عن مال والإبراء عن الدين وعزل الوكيل والاعتكاف والمزارعة والمعاملة والإقرار والوقف وكذا والتحكيم عند أبي يوسف خلافا لمحمد. So these 14 items are you cannot do two things. Ta'liq, which is to put them forward into the future, right? So as we've seen, can you make a sale into the future? No, right? That I am buying this in September. That's a promise. It's not a contract, right? So you cannot make ta'liq, which is into the future, and or I am buying this if my dad agrees. I buy this if my dad agrees. That's not a sale. That's right. So these things you cannot put a condition, whether that I'll get it in the future or make it conditioned on it, and it is affected by corrupt conditions. Right? It is affected by corrupt conditions. As we saw, what happens to the bay' al-fasid, right? And يبطل بشروط الفاسدة, يبطل here meaning it is harmed by it, right? The shart al-fasid would make it fasid, right? So the language is a little bit expansive here. It will be corrupted by a corrupt condition. So the corrupt condition has an effect in these items. Whereas وَمَا لَا يَبْطُلْ بِالشَّرْطِ الْفَاسِدِ, there's other things that are not corrupted by a corrupt condition, which are a lot of items, right? Which are all these items. Al-qardu, wal-hibatu, right? والصدقة والنكاح والطلاق والخلع والعتق والرهن والإيصاء والوصية والشركة والمضاربة والقضاء والإمارة والكفالة والحوالة والوكالة والإقالة والكتابة وإذن العبد في التجارة ودعوة الولد ودعوة الولد والصلح عن دم العمد والجراحة وعقد الذمة وتعليق الرد بعيب أو بخيار الشرط وعزل القاضي. So these things are not affected by corrupt conditions. So for example, the qard, right? You say, okay, I lend you this money on condition that you don't use it for other than such and such. The qard is valid, the condition is not binding. The condition is not binding. The corrupt condition does not affect the item. Simply the condition is not considered. Similarly, you give a gift. Say, I'm giving you this sibha on condition that I gift you this sibha on condition that you make 500 salawat on the Prophet ﷺ every single day. Now, you shouldn't make conditions like that. But if you do, and the person doesn't do it, does it affect the gift in any way? No. Right? It belongs to him. It's not an enforceable condition. Likewise, sadaqah. You give charity and you say, okay, I'm going to help you on condition that you only spend it in clearing your debt. But the person may have debts due, but they have to buy medicine for their diabetic wife or husband. Right? So the condition is not binding, but you cannot deceive the person. Say, yes, I'll use this to clear the debt, but you don't. That doesn't affect the charity itself, but it would be a case of lying and deception. So these are, and likewise, all these other things, similarly, nikah. Someone says, okay, I marry you on condition. Zubayr says to Zubaydah, I marry you for the agreed upon mahar, according to the book of Allah and the sunnah of the Messenger ﷺ, on condition that you can cook biryani. They go home, she can't cook biryani. What happens to the marriage? So you put a condition, right? That on condition that you cook biryani. It does not affect the marriage contract in any way. Okay? And likewise, all these other things, the corrupt commit, or someone is given imara, they're made a leader on condition that you are upright. They're not upright. It does not affect the validity of them being in that position. Tamaman. So that's, this is the final section. We won't, if you want details for each single one, we look at them next. Next we have Kitab al-Sarf, after which we have Kafala. And Sarf is a Sarf currency exchange, because we'll see there's discussion regarding it being a currency exchange per se. So that's where we'll stop. Any questions before we close, Sadati? So we saw today that if two people, so we before we take the question, that manufacturing contracts have a lower threshold than the Salam contract. The Salam contract is very strict. However, what does it require? It requires payment upfront. So manufacturing contract's facilitative, but by default, it has to be something that's manufactured. It has to be customarily transacted in. You cannot specify in the contract itself the date of delivery. Because otherwise, what would it become? It would become a salam. And although it's a binding contract, it's a contract that you cannot go back on once made. But when the item is delivered, the transmitted position of the madhab is it binding on the buyer to accept the item in terms of the
No,
transmitted
yeah,
position? No.
yeah.
They have the khiyar. They have khiyar al-ru'ya. But the fatwa is on the narration from Abu Yusuf that it is binding if as described. Given people's lack of trustworthiness, etc. And then we saw a whole bunch of masail shatta. There's a question: if two people placed a manufacturing order and one disappeared and the second cannot afford to pay all the price, what is the best solution? So one is sulh, right? Is to come to a settlement. Let's say, look, we agreed to buy this, these items, etc. I can't afford to pay. So, and diyanatan, right, religiously, you say, look, but what becomes tricky is if only one person initiated the contract, right? We say, okay, Masir and Khalid said they agreed to buy that fisherman's boat, the one Masir's hunting animal jumped into, right? But who engaged in the transaction themselves? That's one of the aspects, right? Because it's Masir and Khalid, but the guy who negotiated with the fisherman for his boat was Masir. So who's the transacting party? Just the one who engaged in the offer and acceptance with the seller, right? Similarly, that's in general. So one of the ways these are solved, the two people place an order. Say, the two of us are renting a place. No, but who transacted with the landlord? So the same thing would apply in a manufacturing contract, right? If two people place an order, they said it, okay, the two of us are placing the order together. Now, is that two orders? That, okay, I owe you $50 and so owes you $50. So it's two orders placed together to facilitate shipping and stuff, right? So anytime we can break it down either into one person being the transacting party, we do so. If we can break it into two transactions, that simplifies it, right? That, for example, you want to place an order to, 4 students of knowledge decide to put an order for books, and then people need to think about this, right? But you want to be careful because each one is going to be paying separately, etc. But they put it all into an order. You tell the buyer that, look, there are 4 orders here to save shipping. These are 4 transactions. So you break it into 4 offers and acceptances. That simplifies it. But if two people put a manufacturing order together for one set of items, and they can't settle, the basis is that the two transacting parties, if it's not clearly separable, the two transacting parties, each, it's a bit like a sharika. It's a bit like a partnership, right? Each has diyanatan, needs to cover for the other party and then take the money back from them, right? Which is we took before, right? So if Masir and Khalid commissioned for something to be manufactured together, and they're both transacting parties for one sale price, then if Masir doesn't have money right now, then Khalid has to cover and pay for it. Now, if Khalid can't afford it, then you either seek a settlement or seek iqala, seek cancellation. Man aqala nadiman athratahu. Whoever cancels the transaction of one remorseful, aqala Allahu atharatihi yawm al-qiyamah. Allah will cancel their errors on the day of resurrection, etc. The issue of contract conditions within contracts, we saw it earlier when we looked at conditions in contracts in detail. This is just a summary section that which transactions are affected by corrupt conditions and which aren't. But the earlier lesson on Bab al-Bay' al-Fasid, we looked at what are sound conditions and what are unsound conditions, so we can review it from there, inshallah. And if you're following the course online, you can register for the course. The information is in the broadcast. You can register for it and you have access to all the previous recordings. We'll stop here. Wa sallallahu ala sayyidina wa nabiyina Muhammad wa ala alihi wa sahbihi wa sallam. Wa akhiru da'wana an alhamdulillahi rabbil alameen.